Good afternoon, and welcome to the May Family Law Section Facebook Live on Amicus Briefs and the Appellate Family Law Section Committee. My name is Amber Kornreich, and it's an honor to moderate today's program. Before we get into today's substance, we'd like to remind our members to follow the Family Law Section on social media, Facebook, Instagram, and Twitter. Also, please remember that the Florida Bar Annual Convention and Section Meetings is taking place June 21st through 24th in Boca Raton, Florida, and that registration for the Trial Advocacy Seminar is July 13th through the 16th, and it's officially open on the Family Law Section website. Today, we have the pleasure of having three incredible leaders from the Family Law Section, dedicated members of the Appellate Committee, Jennifer Patti, Matthew Thatcher, and Marck Joseph. It's a very meaty topic, so let's dive in. So first, Jennifer, we'll start with you. What is an amicus brief?
These briefs are more commonly referred to as friend of the court briefs. It's an industry or a public interest group that has a unique perspective or a specialized expertise in that matter that can assist the appellate court in the disposition of the case. So under Florida appellate rule, you must actually seek a motion for leave to file a brief. And in that motion, you have to address your interest, particular issue to be addressed, how the group can assist the court in the disposition of the case. And of course, you must have all parties to consent to the filing of the brief.
Thank you, Jennifer. It's a perfect place to begin. So, Mark, why and when does the Family Law Section get involved in filing an amicus brief?
Thank you, Amber. The Family Law Section gets involved with amicus briefs when essentially the issue that's before the court or before the appeals court is something unique or specific in which the Family Law Section does, in fact, feel that it's a matter that they should at least be involved in, whether it be a unique issue of law that where the statute in the case law doesn't exactly match at that point, or if it's something that can significantly affect case law and statute as we know it. That's normally when amicus briefs will usually come from the section, something just to basically have our touch on what's going on, not in the particular matter, but the result of the matter. As you know, as we all know, case law does create precedent that we all end up with as counsel or parties that are representing Florida's families. So that's usually the time when the Family Law Section would step in.
Thank you, Mark. So, Matt, what's the time frame for an amicus brief?
Well, at a minimum, it's going to be 30 to 45 days before we would file. So we're going to want as much lead time as possible. As Jennifer had said earlier, we've got to file a motion with the appellate court 10 days after the filing of the brief that we're supporting for leave to file this brief. But we, as the Family Law Section, have to get permission from the Executive Council to be able to proceed because we're acting on behalf of the Executive Council. We also, under the standing policies of the Florida Bar, have to get permission from the Florida Bar to be able to file this. And also we have to have time to draft the brief. So 30 to 45 days minimum, more time if you can get it.
Okay, so to our members, make sure to have plenty of lead time. So, Jennifer, can you tell me about the last amicus brief that was filed?
Sure. It was the case of Enriquez versus Velasquez. If anyone would like to see the opinion, it is 350 Southern 3rd, 147 out of the 5th DCA in 2022. I'd just like to give quick gratitude to fellow committee members. I was on the committee along with Matt, Christy Mitchell, Ruben Dupay, Sarah Okendo, and Raymond Grimm in the preparation, editing, researching, and the constant communications on our different ideas. So in that case, the mother and father were never married, and they had a child by what the appellate court called an at-home artificial insemination process. And there was never any dispute that the father was the child's biological father. In fact, there was stipulated by court order. So when they went to trial, the issues that were to be addressed at trial were time sharing, child support, school determination, and who would claim the child on their taxes. And although the mother never raised it, the trial court on its own initiative determined that dad wasn't biological dad by sexual intercourse. And although it was never pled or argued that dad never wasn't dad, the trial court held that under section 742.14 of the statutes, which we refer to as the assisted reproductive technology statute, dad couldn't be dad because there was no sexual intercourse. So because they didn't comply with that statute, the court denied and dismissed the petition for paternity with prejudice. So the trial court order was brought to the attention of the appellate committee of the family law section. And from there, a subcommittee was created to determine whether this was an issue that the committee wanted to write a brief on. And Mark will talk about this later. But did this issue have consequences for the greater family law community? And in this case, we decided this is something that we felt was important to the community in whole as it relates to paternity. So the group got together and there was varying levels of experience in appellate. We discussed different morals, legal issues, ethical issues, equitable issues. So you had a great group of people, all with different ideas on how to address this issue. I remember Christy had brought up strict scrutiny, and I was having flashbacks to law school. But from there, we drafted a brief, which went through constant editing, and eventually it was approved and it was submitted. And the 5th District, if you read their opinion, actually reflected on some of our ideas. And it said in the opinion, in the underlying proceedings, there was no dispute that the father's sperm was used to impregnate the mother. That issue is undisputed. The question was whether the sperm was used in the fact that the father was a donor, which is what the statute calls it. And that was our question. Was the father actually a donor under the statute? And that's why the statute didn't apply. And I believe that was one of Matt's arguments, actually. I remember he brought that to the table initially. We also argued that the intent of the parties was something that the trial court should have considered. And this was also reflected in the opinion where the 5th District had said, however, had Enriquez and mother gone into the bedroom on the day in question with the intent of conceiving a child and chose to procreate through sexual intercourse instead of artificial insemination, would he still be a donor under the statute and preclude him from paternal rights? So we took our opinion of what was their intent when this child was created, and did that reflect under the statute? So the 5th District agreed with us in not all of our things. We didn't say we drafted it. The 5th District didn't say, oh, thank you, family law section, for giving us our opinion, but it was reversed and remanded, and we saw a lot of our ideas reflected in the opinion. And this isn't the first time that the family law section has actually come in on a brief. Going back to 2010 in the case of Florida Department of Children and Families versus the adoption of XXG, and that was a case, the brief was drafted by Cynthia Green, well-known and loved, Luis Insignaris, also well-known and loved, and Scott Rubin, who also drafted the opinion. And the 3rd District there actually said, we wish to express our appreciation for the brief submitted in the case. And it cites to the brief from the family law section. In that case, we argued that a parent's homosexuality is not a basis to terminate parental rights, just on that issue. So this is something that we felt very strongly on, and that needed to be discussed. So when it comes to us, it's not just we're fighting for mom, or fighting for dad, or husband, wife, but we have a strategy session and we go at it. We say, well, what about this? What about this? So everybody had the opportunity to discuss their opinion. And from there, we came up with a cohesive brief that we felt strongly represented the opinion of the section, or reflected that would be good for the family law section in whole.
The theme, as you're kind of gathering from those 2 briefs that we've done, is that the section gets involved in these higher level issues that have larger ramifications for the family law bar as a whole. I mean, Enriquez was not just about a particular family, although it affected a particular family. This legal decision could impact future paternity cases and future families that choose to create children without going through an expensive fertility clinic. The other cases where the section has weighed in have also impacted ways in which Florida families are constituted and created, because this affects our practice and our clients. So these weighty issues are really the kind of issues that we're looking for to be brought to the committee for us to explore. But because they're so weighty, that's why we need sufficient time to do all the back and forth that Jennifer's talking about, to come up with those creative ideas and arguments, because that can't be turned around in a week. That's why we need a month, 45 days, to be able, or longer, since you've got 70 days from filing of your notice of appeal to file the initial brief. And our brief has got to be filed within 10 days of the brief that we're supporting. And 9 times out of 10, that may be the petitioner. That's where we need that lead time we were talking about.
And last thing, I'll chime in. Jennifer made a good point. This gets vetted. Like, it has to go through channels. And aside from the time frame, it's not just whether or not a particular person of the group comes in and thinks, oh, this is important. It has to be something that the committee agrees is important. And then the executive council has to agree is important, of the family law section. And then the Florida bar has to agree. So, there is some very serious consideration taken at all levels before it's decided, okay, now we're going to chime in. So, of course, I would also say, like, just because you may not believe your position may be that serious or not, the worst thing that can happen, and we'll discuss a bit more, is you let us know so we can at least start the process and go through that filtration to determine if it is something, because you'll be surprised what could be greater issues, whether you believe it or not.
Really interesting. So, Mark, continuing on that same topic, how do I, or a member out there who's watching today's Facebook Live, submit a potential case for an amicus brief?
All right, great question. So the official email for the committee, and I want to make sure I get this right, it's appeals@familylawfla.org. This is the specific email that we use to receive this information. Obviously through the years, there's various people who operate as chair, vice chair, and secretary. That changes, but that email does get sent out to the people who kind of handle that. And then from there, that's when it gets to the committee. So that's the best way to make that contact to get the process rolling.
And bouncing off that, when we received the Enriquez issue before us, we were made aware almost immediately when the order came out from the trial court. We were told this went up on hearing, this is what happened, we have a fear this is going to happen. So before the trial order even came out, we were aware. So if you've got something that's coming down the pipe, or an issue that you think is going to be something that might go up on appeal that we might want to consider overall. Now, again, we're not picking one side over the other. When we do these, we prepare these briefs. It's not to support a party over the other, but the effort is for the whole family law community. So if you have something, or if you have a trial order, send it to us. We will address it. And if you haven't heard back from us, follow up with us. But it's something that, let us look at it. We'll get back to you, say we'll want to do a subcommittee. And then if it's something we decide we want to consider, we'll have you come in to a Zoom with the subcommittee and discuss it with us. That way we can understand why this is so significant. And there have been people who've come to us and we've said, not at this time. There are people who have said, this is a great idea. Keep in touch with us and keep the progress. But if we don't know as soon as possible, again, it might be a fantastic idea. And there have been very good ideas that have come up. But it's already been filed, the brief is done, and you're coming to us well beyond the time frame that we can do something. So again, it's never too early. And I think we've said that plenty of times throughout this presentation.
Thank you, Jennifer. And so, Matt, I know that you're particularly passionate about the appellate committee. How do I, or one of our audience members today, get involved with the appellate committee?
Well, the first step is to send an email to the static address that Mark mentioned. And that way we can know that you're interested, and we'll put you on the roster of the committee. And when we have meetings, we'll be able to send you out an agenda and make sure you're included and you're aware of what's going to happen. We are going to be having committee meetings coming up at the Florida Bar Convention coming up in June. Even if you're not on our list as an active member, show up. Our door is open. We'd love to have people come in and join us. And the other way is just reach out to some of our current membership. Our roster is available online on the section website.
And everybody has ideas on the appellate committee. It doesn't matter whether you're a practicing appellate attorney or you just have an interest. Come and join us and learn. I've learned so much from this committee. There are amazing people in this committee that are willing to help and willing to discuss ideas. But don't feel like this isn't something that, even though you're not practicing, you can't come join us. This is an invaluable experience for most attorneys.
Yeah, and to Jennifer's point, it doesn't matter if you do appeals regularly in your practice or you just have a curiosity about it. I think at different levels, any attorney can benefit on at least joining the committee, or at least knowing what the committee is up to. Just like many of the other committees in the section, it's kind of open for all the members there, the family law members there. But, come in, see what's going on with it, see how it's moving, because you don't, like with the Enriquez case, like sometimes they're very interesting issues that may affect your cases, not even in the future, but right now. So it'd be very curious to know what's moving and shaking in this committee.
Well, thank you all so much for your time and diligence today. It was so interesting learning more about the appellate committee. We hope that many of our audience members will follow up to submit their cases for amicus briefs and to join the appellate committee. So thank you all for your dedication, and we look forward to seeing you next month. Take care.
Amber.
Thank you very much, Amber.
Bye-bye.